Hey everyone, welcome to another Legal Friday edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me as he does every Legal Friday, Alex Ooley from the Ooley Law Offices in Indiana, also the O2 Training Group. Alex, how's it going today, man?
Yeah, it's going great. You doing okay, Paul?
Doing fantastic. As I do every time we do this, I want to throw a reminder out to everybody. We are not going to be giving out legal advice. Alex is an attorney in Indiana. However, he cannot give out legal advice to just anybody, blanket style. If you're in Indiana and you need legal advice, get a hold of Alex, and we'll let you know how at the end of the show. If you're anywhere else and you need legal advice, get in touch with an attorney in your jurisdiction who's licensed to practice law where you're at. If you're catching us live on the Polite Society podcast, YouTube, and Facebook feeds, go ahead and comment on the live video. If you're catching us anywhere else, OpsLens or any other page, go ahead and go to Twitter and tweet with the hashtag #TheBullet. We'll get those comments up and get them on the air. Actually, and if you have any legal questions, go ahead and feel free to ask. Let me get social media hooked up here. Just waiting on Facebook. Yep, we're all connected. So, Alex, first of all, I want to mention it is, as of today, 810 days to Inauguration Day. So, just a little over 2 years, and we'll have another inauguration. Let's just hope it's not Biden/Harris version 2. Stories I had selected, and we talked about this first one quite a bit this week. We had a judge in New York, and I'm trying to look up his full name. I've been terming him Saint Sotheby, Judge Glenn T. Sotheby. Early this week issued late last week issued a preliminary injunction in the Antonyuk versus Hochul case. Struck down a good deal of the New York Concealed Carry Improvement Act. And this week, the Second Circuit reversed it and reversed his injunction. And so what I'm wondering is two questions for you. First of all, Judge Sotheby is a Western District of New York federal judge. I'm guessing Western District of New York does not include New York City. If Sotheby issues a ruling, does New York City have to abide by that federal judge's ruling?
Right. So I think it bears some discussion about the structure of our courts, and then I'll get to your question. Just I want to give a little bit of background here. Okay. So, we have the United States Constitution, and each state has their own constitution, and then there are state courts and there are federal courts. What we're talking about here are federal courts, but state courts basically follow the same structure in that we have the Supreme Court of the United States, which is the highest level court. Then we have intermediary, what are called circuit courts. And there are 13 of those. There are actually 11, and then the DC Circuit and the Federal Circuit, which hears cases of special types of certain subject matters. And then within those circuit courts, there are district courts or trial level courts. They're the lowest level courts. And Judge Sotheby here is in the Western District of New York. So he's at the lowest level court. And I'm not sure how many districts there are in New York. I believe 3, but I'm not positive about that. And he is the judge in one of those districts. So he issued, as you recollected that he issued a preliminary injunction, I think it was the 7th, so a little over 10 days ago, against the Concealed Carry Improvement Act and certain provisions of that act that were passed on the heels of the Bruen decision. And that preliminary injunction was stayed by the Second Circuit, so stayed by the intermediate appellate court. So it wasn't really reversed, but it was stayed until the case could be heard before the Second Circuit panel, which would be 3 judges on the Second Circuit.
Okay.
So it's possible that his decision could be reinstated or put back into effect, but that would be done by the Second Circuit. And the Second Circuit includes, I believe, New York, Connecticut, and Vermont. I don't recall exactly, but I think that's correct.
I think New Jersey is in the same district as New York, I think.
It may be in the Third Circuit, but I wouldn't swear to that. I can't remember the map up there exactly. But New Jersey's either the Second or Third Circuit. And so the Second Circuit decision would apply to the entire Second Circuit, which would include, obviously, Vermont, Connecticut, and New York, and then maybe New Jersey. Whereas the decision from the Western District judge would only apply to the Western District of New York. Now, you asked if New York City would fall under that, and New York City is not in the Western District of New York. And there's this difference between what's called binding precedent and persuasive precedent. Okay, so if there's a court in your jurisdiction or a court within the Second Circuit that's made a decision about a particular issue, that decision is very persuasive. Whereas if it's a decision from the Third Circuit, that may be persuasive as well, but certainly not binding. Okay, that's the clear distinction if you're in a totally different circuit. So that's why the Second Circuit, I believe, has taken this issue up. Obviously, it's a case of extreme public importance. There are fundamental rights at issue here, and the Second Circuit, I think, will hear it relatively soon.
One would hope, and honestly, I'm hoping it gets to the Supreme Court rather quickly. I think that's where a lot of these are going to end, with the Supreme Court.
Yes.
We've got a couple more cases we're going to talk about today that are in and of themselves creating splits. And so, and we've discussed before, one way to encourage the Supreme Court to take a case is if, for example, the Second Circuit rules no, you can't, and the Fifth Circuit rules yes, you can. If there's a split, then it's more likely, nothing's ever definite, but more likely that the Supreme Court will take the case.
Right. So if the Second Circuit makes a decision that is different than the Fifth Circuit or any other circuit, the Supreme Court is much more likely to take up that issue because there's disagreement among the circuits. And you got to remember, the Supreme Court, I think there are like 8,000 petitions for review to the United States Supreme Court every year, and only about 1 or 2% of those are actually considered. So the court has to prioritize which cases they hear, and one of the ways that they prioritize cases is by reviewing circuit splits.
Sure. Well, and you said only 1 or 2% are considered, and I'm thinking a very small part of those are accepted. So it's almost, I mean, not quite, but almost a lottery win to get up in front of the Supreme Court with your litigation.
Yeah, and that's why organizations like the Second Amendment Foundation, the Firearms Policy Coalition have to be very selective about the cases they take, because they can't get to every issue, but they need to get to the most important ones and to the ones that they're most likely to prevail on, and that includes potentially at the Supreme Court. So the Second Amendment Foundation and other organizations that litigate Second Amendment issues have to be very intentional about which cases they take.
Yeah, absolutely. next case I want to talk to you about, this one broke this week, and the Third Circuit has ruled that a man who pled guilty to understating his lawn mowing income to obtain $2,458 in food stamps had no Second Amendment right to own a gun. This gentleman, obviously a nonviolent felon, and a lot of us have been arguing for a long time that nonviolent felons ought to be able to have their Second Amendment rights back. Looks like the Third Circuit in this case disagrees.
Yeah, it was interesting, the analysis that the court went into here. They conducted a historical analysis, but they sort of drew this distinction between people who are dangerous and people who have are of high civic that have high civic morals. I'm trying to find the wording they used exactly, but they basically said you had to be to have Second Amendment rights, you had to be a good, law-abiding citizen, and whether or not you were dangerous was not really the point, and that there was historical precedent for depriving people who were not law-abiding from possessing firearms. It seems like a little bit of a stretch to me. I personally don't think that people who have been convicted of nonviolent crimes should be deprived of their individual liberty. If you're not dangerous, then why should you be deprived of that right? So I think the court went through some logical sort of gymnastics here to come to a conclusion that they wanted to come to.
Yeah, absolutely. And let me do a fast Google search here. And we have Delaware. Okay, I was wrong. Delaware, New Jersey, and Pennsylvania are in the Third Circuit.
Okay. So the Second Circuit's New York, Vermont, Connecticut, and New Jersey's in the third.
Yeah.
Neither circuit is particularly friendly to the Second Amendment. There's no doubt about that.
Yeah. And yeah, it's Connecticut, New York, and Vermont are the only states in second. So, yeah.
And interestingly, the Heller decision stems from a case that was in the D.C. Circuit. And what's interesting about that is at the time, the Second Amendment had not been incorporated to apply to state governments. Because remember, when the Bill of Rights was adopted, it was meant to only restrict federal government action.
Right.
And through a process of selective incorporation, certain amendments have been applied to state government action. And so when the law, when there was some thought about challenging Second Amendment restrictions, it was going to have to be, or really the best way to do it was through federal government restrictions, through challenging federal government restrictions. And so that case, the Heller case, was brought in the D.C. Circuit because Washington, D.C. is a federal enclave. So
Right.
It wasn't challenging state law, it was challenging federal law in the federal enclave of Washington, D.C. So it challenged the federal law in D.C., and then a few years later, in the McDonald case, the Second Amendment was determined to apply to the states as well through the 14th Amendment.
Well, and I'm going to say fortunately, at least in today's political stand, it's fortunately, D.C. as a federal enclave does not get senators, although the population of D.C. is larger than some states, does not get any representative. They get a representative, they just don't vote. And so there is no federal representation for residents of D.C. And yeah, it's its own special case. So, and even the mayor of D.C., I don't know how much power the mayor has. There are no state level rules. There are just Washington D.C. Local laws, and then there's federal law, right?
Right.
So,
and one thing I want to point out too about this Third Circuit case preventing nonviolent felons from possessing firearms, I'm a little bit concerned that the Supreme Court has. I'm not sure what the Supreme Court will do with this, but I'm skeptical that the Supreme Court will say that felons can have Second Amendment rights. And I say that because if you look at the Bruin decision, it's littered with the phrase law-abiding citizen, and that we shouldn't deprive law-abiding citizens of the right to keep and bear arms. And I don't know that, I mean, that's not necessarily binding language in the opinion. It could be just considered what's called dicta, but I think that language sort of points to where the Supreme Court is headed on this issue. I hope I'm wrong on that, but I'm concerned that that's where we're headed.
one of the things when Amy Coney Barrett was up for, when she was nominated to become a member of the Supreme Court, one of the things that was often discussed, and I even heard it on the mainstream media, is that she had written an opinion when she was in a circuit court, when she was on the Circuit Court of Appeals, stating that felons should be able to get their rights back once they've completed sentences. And that caused no small amount of consternation among those who are opposed to her being put on the Supreme Court. So I'm hopeful that should this get to the Supreme Court, she would be able to sway others up. I don't think Justice Thomas would take much swaying, but she would be able to help sway others to her opinion on that as well.
Yeah, that's right. She was in the Cantor versus Barr decision. She wrote a dissent where she advocated for basically that nonviolent felons should not lose their rights indefinitely. They've done their time. It wasn't a dangerous crime that they committed, so why should they lose the right to protect themselves? And interestingly, the Cantor versus Barr decision was addressed in a footnote in the Bruin decision, saying that these are decisions that need to be reconsidered because they applied the wrong analysis, because Cantor versus Barr and other cases that had been decided in the various circuit courts applied the interest balancing test in one way or another, either through intermediate scrutiny or strict scrutiny, and the Supreme Court clearly rejected those forms of analysis with respect to Second Amendment challenges in the Bruin decision. So I don't think the Cantor versus Barr decision would come out differently in the Seventh Circuit, but the court did say that it was decided wrongly based on the analysis that was used.
Sure. One more story I want to get to today that's legal, and this story is off of KRS-TV 6 News out of Corpus Christi, and I'm going to go down in the story here a little bit. A federal judge's recent ruling on gun rights raised a red flag for domestic abuse victim advocates. District Judge David Counts, who serves in the Western District of Texas, ruled it was unconstitutional to take gun rights away from people under a protective order. This all goes back to, on the federal side, this goes back to the Lautenberg Amendment, is where the people who have restraining orders against them lose their right to keep and bear arms. Something I think you don't have to, how do I put this? you have not been convicted of a felony, it takes next to nothing to get a restraining order. You and I have talked about this a little bit in the past, in that the judge is going to err on the side of safety almost every time. So even if the person who's trying to bring the protective order is lying, they're probably going to get at least a temporary restraining order, maybe permanent. So I think this is good news. I think that it should take a felony conviction for you to lose your gun rights.
Yeah, like you said, that the dynamic that exists for judges to rule on these is not favorable to individual rights, because the judge doesn't want something to happen and then the blame fall back on them for not restricting the person's gun rights, or for not issuing the protective order. So the judges have this incentive to issue these protective orders, even where there is a lack of credible evidence that they are necessary or legitimate. One thing I would note is that 18 USC, so this is United States Code, 18 USC 922, this is G8, so subsection G8. It says anyone who is subject to a court order that was issued after a hearing of which such person received actual notice and at which such person had an opportunity to participate, and restrain such person from harassing, stalking, or threatening an intimate partner of such person or child of such intimate partner or person. And this goes on. Basically, it is this protective order language, but it says after a hearing. And the problem is, like we said, the judges have an incentive to issue these even after a hearing, and trial court judges are very rarely overturned on these issues because they're considered the finders of fact, and appellate courts only review the findings of the trial court judge typically for abuse of discretion. So trial court judges know when they issue these things, they're very, very unlikely to get overturned, so they'd rather err on the side of caution.
Well, and one thing, Jeff Knox and I, years ago, were talking about the Lautenberg Amendment when he was interviewed on Polite Society. And I want to say this is 6 or 7 years ago, back when I was doing very long podcasts. And he brought up something interesting, and that is this, that it's commonplace and almost immediate that if there are people going through a divorce, it's almost he gets a restraining order against her and she gets a restraining order against him. So if you want to keep your gun rights, don't get a divorce. Well, this shows some hope to that.
Yeah, and typically, and we talked about this a little bit off air, in the divorce context, they're not typically restraining orders from contact. They're typically restraining orders from disposing of property without an order from the court or without a hearing. So because they don't want one spouse to
get rid of the Jaguar, yeah,
right, or sell assets without fully litigating the case in court. And one thing I want to mention too is that the Lautenberg Amendment addressed crimes of domestic violence as well, not just protective orders. So if you were convicted, normally you're prohibited from possessing a firearm if you're convicted of a felony. But if you're convicted of a misdemeanor crime of domestic violence, that also prohibits you under federal law from possessing a firearm. So even where it's just a misdemeanor, if it's a misdemeanor crime of domestic violence, that would preclude you from owning or possessing firearms and ammunition.
Okay.
So even where there's no protective order necessarily. So for instance, I see this a lot. Somebody pleads guilty or is convicted of a misdemeanor domestic battery. The protective order stays in place during their incarceration, during their probation, if they have probation, but then it's terminated, the protective order ends upon completion of their probation or completion of their sentence. Well, just because the protective order has gone away doesn't mean they're not prohibited anymore, because they've been convicted of the domestic battery, even if it's a misdemeanor.
Sure. So let me ask this, and we're going to limit this specifically to Indiana, so we can go on your knowledge. If someone in Indiana, let's say they're splitting up, and there is a protective order issued against either person, but no crime has been committed. The allegations of threatened violence, and judge issues the order. When the order goes away, when the order is settled and the divorce is settled and everything's done, does the person who had the order issued against them get their gun rights back?
Yes. So as soon as the protective order is terminated, then it's no longer in effect, and you're no longer subject to that order. So as long as there's been no crime, there's no conviction, you can get your guns back.
Okay. All right. Very cool. Well, we are right down near the bottom of the hour, Alex. I want to mention you're going to be back with us tomorrow for the weekend edition of the Bullet, right?
Yeah, looking forward to it.
All right. Well, on the way out, tell us about the O2 training group. Tell us about anything else you want to plug, man.
Sure. So we've talked a little bit about felons and gun rights, but just because you've been convicted of a felony or even a misdemeanor crime of domestic battery or domestic violence doesn't mean you can never get your gun rights back, and that's something we can help people with through an expungement or some restoration of rights process, depending on the particular situation. So if that's something that you or someone you know is interested in, look us up at ooleylaw.com, give us a call or send us a message. We also have a firearms training business, O2 Gun Group, where we teach a 5-hour class about the lawful use of force in self-defense. We think it's sort of the essentials that people need to know about the law if they plan to exercise their right to keep and bear arms. And we certainly don't advocate that training should be required, but we think that rights come with responsibilities, and that we should exercise our rights responsibly. So we teach the legal class as well as some handgun courses as well. So check that out at o2gungroup.com.
Very cool. On my end, I want to plug tomorrow at noon Central. We're going to be having the weekend edition of the Bullet. That is basically a week in review, where we take a overview of the most important stories of the week. We don't catch all the stories of the week, but we go over the most important ones. And I think Sotheby's going to be in there again this week, although I haven't got everything put together yet. Your other commentators tomorrow, besides Alex, will be Dan Waz and Beth Alcazar. And come join us noon Central Time tomorrow for that. And then next week, we have Thanksgiving coming up. There's going to be regular Bullet broadcasts Monday, Tuesday, Wednesday. And then Thursday is a holiday, no Bullet broadcast. Friday, I've got an obligation that's going to take me out for several days. I'll be back probably Friday of the following week. So we're going to be taking a short hiatus so I can take care of some personal issues. But everybody, thank you for watching, and thanks for contributing, everybody, throughout the week. We're going to set this one aside. We'll see you tomorrow. Thanks for watching, everybody.